So I'd like to welcome everyone here today to Monash Law's Law and Business Seminar. And I'm Jennifer Hill. I'm the Director of the Centre for Commercial Law and Regulatory Studies, or CLARS as we call it. And I'm quite excited about today's seminar. I know that we have participants from Melbourne, around Australia and around the world. Before we get underway, I would like to acknowledge the traditional custodians of the land on which I'm calling from today, and I pay my respects to elders both past and present, and I extend that respect to other Aboriginal people who may be participating in today's event. So our seminar today is on such a topical issue, why privacy matters. And the description of the seminar that we put out to all of you started with this statement. It said, everywhere we look, companies and governments are spying on us, seeking information about us and everyone we know. Ad networks monitor our web surfing to send us more relevant ads. And I should note that our mobile phones are also keeping tabs on where we go. Last week, I attended a regulatory seminar in Parliament Square in Melbourne, and by the next morning, I was receiving advertisements on my phone asking, would I like to lease office space at that end of Collins Street? And the answer was no. So today's discussion is very topical. The New York Times, only a week ago, ran an opinion piece, the title of which was, "We're about to find out what happens when privacy is all but gone." And so today we're very fortunate to have one of the world's leading experts on privacy and why it matters, Professor Neil Richards, to talk on this topic. Neil is the Koch Distinguished Professor in Law and Director of the Cordell Institute at Washington University in St. Louis, and he writes, teaches and lectures about privacy law, information law and freedom of expression, and also about how technology is revolutionizing and changing the way we live our lives and society today. These issues are also dear to the heart of our commentator today, my friend and colleague, Professor Chris Marsden. Chris is Professor of Artificial Intelligence, Technology and Law at Monash Law School, and he's also my colleague in CLARS. So he's an expert on the internet and digital technology law. Before we get underway, if I could just let participants know, you are very welcome to put questions in the Q&A box as we go along. We will try to answer those questions when we have the discussion at the end. If I could ask everybody though, please, when you do put your questions in the Q&A box, could you please identify yourself and the organisation that you're from? And at this point, I'm going to pass over to Professor Richards. Over to you, Neil.
Thank you, Jennifer. It's really a pleasure to be here, even virtually with you all. And I should also probably add that I'm coming to you today from the past, or I suppose traveling to the future. It's about 7 o'clock in the evening on Wednesday here in St. Louis. So I'm going to talk today about my recent book called Why Privacy Matters, and it's about, funnily enough, why privacy matters. And the book is a long form of a conversation that I've had with literally dozens, if not hundreds of people around the world over the last 10 or 15 years. And it's a conversation that I have all the time. And it's one that I've taken to calling just the privacy conversation. The privacy conversation, the time that it really struck me that I was having it all the time was appropriately enough in Silicon Valley. I was in Palo Alto. I was staying at a hotel, about to give a talk on my first book, Intellectual Privacy, at Stanford Law School. And like a lot of people, I called an Uber. And I get in the Uber and I said hello to my driver. And she said to me, "Oh, you're going to Stanford. What do you do?" I said, "Well, I'm a law professor." And she said, "Well, what kind of law do you do?" And I said, "I do privacy law." And as soon as the words privacy law crossed my lips, I knew what was going to happen. One of two things happen. Some of the time, someone will just say something like, "Oh, you must be very busy then." And we go, "Ha ha," and we have a nice laugh. But the other times, the more interesting times, they they sort of make a sad noise and they go, well, privacy is dead because, and this is what the woman did this time, because all my information is out there. It's really creepy what they're doing with my information, but at least I have nothing to hide, I guess. And it wasn't crazy for her to say this to me. After all, we were in a commercial transaction that was being modulated by an app that was monitoring both of our locations, that was handling payment and various other things, and even beyond the context of the Uber ride. It's not ridiculous to think, as the New York Times editorial board, as Professor Hill said a little while ago, said last week, that privacy is dead or privacy is dying. After all, CCTV cameras are everywhere, drones are in our skies, governments and corporations are deploying facial recognition technology. For example, Manchester City recently trialed a convenient ticketless option to scan people's faces in lieu of tickets, and also to scan faces for potential criminals and troublemakers. I'm a Liverpool fan, so I enjoy picking on Manchester City, but it's not just dubious corporations run by petrostates that are engaging in facial recognition technology. I know that Bunnings and Kmart recently in Australia have gotten in trouble for the same thing. So too has Taylor Swift, who was using facial recognition technology, the same company that provided the technology to Manchester City, to identify potential stalkers at her shows. What they would do is it was framed as a fun photo booth where you could get into a photo booth and take a selfie with Tay-Tay, but while you got your picture with her or with her digital avatar, you were being cataloged and scanned to be sure whether you were undesirable. Beyond facial recognition, of course, there are the Snowden revelations. There's the Cambridge Analytica scandal. And there's the prevalence of connected home devices with microphones in them, like the Amazon Echo, which is always listening, always on, often eagerly sought by law enforcement for the evidence of microphones in people's homes in things like murder trials. And of course, I should also mention, this is not my Amazon Echo and this is not my wife. This is an actual advertising image that Amazon used to advertise the Echo. In some countries, it's called the Alexa. In any event, back to the Uber ride. The Uber driver, I think, was quite reasonable in suggesting that privacy is dead. The problem was, for the next 7 minutes, my poor Uber driver was subjected to a mercifully short, because it was a 7-minute ride, an argument from me that, well, I understand that you think that privacy is dead, but actually it's not. Certainly there can be no debate that privacy is under threat, but it's not dead. Instead, it is up for grabs. And the reason it is up for grabs, and the reason it's so important that we resist this argument that privacy is dead or privacy is dying, is because the privacy is fundamentally about power. If there's only one thing you take from listening to me this evening, this morning, or whenever it is, wherever you are, it's this: that privacy is about power. The very organizations that would so assiduously try and deny the importance of privacy know that privacy is about power, right? The reason that the NSA was so interested in listening to our telephone calls or finding out who we talked to, Americans, Australians, people all over the world, is because they know that information about our contacts gives them power when it comes to investigating and deterring activities, in their case, terror. But the power effects of information are clear. Similarly, all of those ads that are following Professor Hill around her travels in Australia are there because they want to predict her behavior so they can get her to buy things. Now, maybe office space was a bad target, but there are certainly other things that she might be willing to buy. Advertisers know if they can have the right information to get the right pitch to the right person at the right time, they can use the power of that information to influence consumer behavior to get them to buy things they otherwise wouldn't do. Now, the fact that privacy is about power doesn't mean that it is always sinister. Some of the law enforcement uses of human information are valid, at least when they're within the rule of law. Parents use baby monitors to check on their children, a surveillance device in the bedroom of their child. Even other people, in my own life, my wife and I use the Find My Friends feature to keep an eye. This actually is my wife and my children. To keep an eye on where they're going, particularly because this guy in the middle, who is 16, has just started driving. Stay off the roads if you get anywhere near St. Louis. In any event, privacy is about power. And in my talk today, I want to do three things. First of all, I want to talk about what privacy is, how we should think about privacy. Second, I want to suggest some things that privacy isn't. And I want to bust 4 myths that are quite common, but ultimately pernicious about privacy. And finally, I want to suggest 3 values that should guide our privacy rules governing the power effects of human information as we move forward into the middle of the 21st century. So what is privacy? Let me offer a working definition of privacy as the degree to which human information is neither known nor used. This is a purely descriptive definition, but there are 4 parts of this definition that I think are worth a little further discussion. First of all, I'm talking about information. I'm not talking about decisional privacy like the sort that was raised by the now infamous Dobbs decision in the United States over the summer, overruling the half-century precedent of Roe v. Wade. Information privacy is not about decisional privacy, but of course they are related. They both deal with power. They both deal with people's ability to make decisions. And if you look at many of the issues in the abortion context, even the ones that are fundamentally about freedom and autonomy have information privacy elements. So for example, a spousal notification requirement for an abortion, as we saw in the Planned Parenthood v. Casey case in the 1990s, that's an information privacy, or you must tell someone, or information collection rules around reproductive health services also implicate information privacy. But information is my primary focus here. Second, it's information about humans. We use the same technologies to surveil humans, to keep track of our pets, or to monitor the temperature of crops, or sensors to monitor climate change. Now, cats may have privacy rights. I don't know. That's not what I'm interested in. I'm interested in information about humans. Focusing on information about humans also suggests or leads us to thinking about human values. And I think that it is human values that should guide our privacy policy more than anything else. Third, I'm interested in information, not just that is collected or known, but how information is used. Many people, like my Uber driver that day in 2016 in Palo Alto, have this understandable anxiety that my information is collected and it's out there. But of course, as privacy lawyers, we know that the interesting questions actually begin when information is collected, and we talk about use restrictions rather than the privacy conversation ending entirely. And finally, it's important to recognize that privacy is a matter of degree. Privacy is not on or off, up or down, public or private. Most information about most people, most of the time, for most of human history, has existed between the extremes of something that is purely private, like the dream I had last night that I haven't told anybody, and so purely public that almost everybody knows the fact, like the fact that John Lennon and Paul McCartney were in the Beatles. Most information is in between those extremes, and I think our privacy discourse, our privacy conversations, our privacy rules, our privacy norms, our privacy ethics should meet the information where it actually is, which is in the middle between purely private and entirely public. So if privacy is about power and up for grabs, how do we protect it? Well, of course, we first have to recognize that privacy is about power. Second, I think we need to recognize that Struggles about privacy are in reality struggles over the rules that constrain the power that human information confers. That's what's going on in all of these privacy disputes. Human information is being collected. That human information has power effects on people, and we have to talk about whether we should have a rule or not that should constrain or shape the exercise of that power. And if so, we have to ask what that rule should be. From that perspective, we really don't have a choice about whether or not there's a rule. Doing nothing is a choice. And so privacy rules of some sort, including let businesses or governments do whatever the heck they want with our information, are inevitable. So we have to make a choice. And in making those choices, I want to argue, we should think about privacy not as a good in itself, but in instrumental terms, something that is going to get us other good things that we might want. So we should think about privacy, or the decision to make things private or make things less public or make things confidential or restrict sharing or collection, in terms of promoting human values. And if we can have privacy that promotes a human value, then we should take it very seriously. That begs a final question: is what human values count when it comes to privacy? And I think three values are particularly important, and good privacy rules can advance these values significantly. They are, first, developing our identities. Who are we? What do we believe? Second, the privacy is central to our political freedom and our ability to exercise democratic self-government. And third, privacy is essential to reasonable, progressive, sensible consumer protection for the 21st century. So that's what privacy is. Let me say a few words about what privacy isn't. One of the problems with talking about privacy is that it means many, many things to many, many people. And there are a series of seductive but ultimately dangerous myths and fallacies that come up anytime we talk about privacy. So let me talk about four of them. The first is the idea that privacy is merely just about hiding dark secrets, and people who have no dark secrets, who have nothing to hide, have nothing to fear. The second is a perhaps natural human reaction that privacy is about creepiness, that it's about stopping creepy things that happen with our data. The third, one that's quite common in regulatory efforts, is that privacy is really about controlling our information. And if only we could give consumers or citizens greater control, we'd solve the problems of privacy. And fourth, there's this notion that privacy is dying. All of these are myths, and let me explain briefly why for a few minutes. First, privacy is not about hiding dark secrets, nor do people with nothing to hide have nothing to fear. This is the case for a few reasons. First, well, putting to one side the fact that the nothing to hide argument was first advanced by Goebbels, a literal Nazi. Another problem with nothing to hide is that it's wrong in its own terms. Everyone, all of us, everybody on this call, everybody you know, has something to hide. For example, almost all of us believe we deserve privacy around our bodily functions. We all, or almost virtually all of us, wear clothes, right? Which is why the dream of turning up to work, or for us academics, delivering a lecture, having left our pants at home, our trousers at home, is one that is so terrifying. In addition, we all have an important human need to share information confidentially with other people, whether that is talking to our friends or our loved ones, or going to the doctor. I had a physical last week, and I've known my doctor for a while, but he brought in a resident, and there I was, essentially half naked, talking about my deepest medical secrets to these physicians in order that they could better treat whatever ailments I may or may not have had. But critically, the promise of confidentiality was what enabled me to share those symptoms and concerns, not just with my doctor of the last 10 years, but with a brand new medical resident who was observing, who I'd never met before and would probably never see again. More fundamentally, the nothing to hide argument misunderstands why privacy matters. Remember, privacy is fundamentally about power, but nothing to hide as an idea focuses on privacy as an individual matter, when privacy is in reality a social value. We all benefit from living in a society where other people are able to exercise privacy. And the analogy here to masking during the COVID pandemic, and hopefully we're done with that, is important. We wore masks to protect other people. We all benefited from the social. Also, masks weirdly covered our faces, which is a kind of privacy in and of itself. But we all benefit from living in an environment in which other people are not spreading viruses or information about us. And when it comes to politics, in a democratic society, we benefit from living in a society where dissidents, eccentrics, and weirdos have the opportunity to put forth their own views of what a good society looks like. Many of the most important political beliefs we have, the equality of all people, regardless of race, gender, sexuality, or other metrics, were ones that people literally died for, or the separation of church and state. And we need to provide spaces for the next generation of political visionaries to generate those ideas for us. Finally, as Edward Snowden put it well, arguing you don't care about privacy because you have nothing to hide is no different than saying you don't care about free speech because you have nothing to say. Okay, so the second myth about privacy is that privacy is about creepiness, and that if only we could stop creepy information practices, we would solve privacy problems. The problem is that which is creepy is a really bad metric for determining whether there is actually a privacy problem. First of all, as a guide to whether we have a problem, creepiness is just over-inclusive. I mentioned I'm from the north of England, which is where the Industrial Revolution first happened. And this is Stephenson's rocket, the first prototype passenger train. Stephenson's rocket was set up in I think maybe in Sheffield, but it was set up in Britain with a length of track and the train and a passenger carriage behind it. And they put on rides for these men in top hats and these with monocles and these women in corsets. And as the train trundled down the tracks at the then unprecedented speeds of 20, 25 miles an hour, people fainted. There was a great belief that this unsettling behavior was one that would cause people to die if they went faster than about 30 miles an hour. Of course, it was creepy traveling that quickly, but it was nonsense. And some other technologies, even digital technologies, have seemed creepy. I have plenty to say about Facebook's abysmal privacy record, but Facebook's newsfeed feature that was rolled out early in its life, pushing your friend's news to you, was revolutionary and was seen as creepy and a privacy invasion. Actually, it was one of the few things on Facebook that had decent functionality. More fundamentally, creepiness is under-inclusive. There are many things which we don't think of as creepy that turn out to be really bad for us. Think about anonymous social scoring, for example. If you don't know that you're being secretly scored and being judged, you might be denied social opportunities. But if you don't know that it's happening, it never registers as creepy. And so the creepiness test just doesn't help us identify real, meaningful privacy problems, which, as I've mentioned, are the ones that involve the inappropriate exercise of the social power that human information confers. Finally, creepiness is malleable. Creepiness reaction rests upon social expectations, which vary across time and across cultures. And companies know this, and governments know this, and they know that they can shape social norms to make previously unthinkable privacy invasions seem normal or even routine. For example, being searched, standing with your hands in the position of surrender while your underwear is scanned by by armed government officials every time we board a plane. That's an example of the ways in which our privacy reactions have been shaped, or metal detectors in schools in this country, where the failure of firearms regulation has meant that many children live in fear. Companies sometimes confess they know that it's malleable. In a rare moment of candor about 12 years ago, the then Google CEO Eric Schmidt said, "Our policy is to get right up to the creepy line and not to cross it," suggesting that creepiness, while it's a natural reaction to many privacy problems, probably isn't a good guide to solutions. Third, and this is one for the lawyers or the coders, privacy should not be seen as being about control. The argument is, well, if we just give people more control, we give them these privacy switches, they'll be able to sort out their lives. First of all, control is overwhelming. More control is often sold in very simple terms as just turning privacy on or turning privacy off. The reality, though, is privacy dashboards are quite complicated and often have settings that most people don't understand. They constantly change, they're often hidden. And of course, we don't just have one set of buttons for privacy, or even a series of sets of buttons of privacy. We have a series of sets of buttons that are hard to find and constantly changing for any one of a host of dozens or hundreds of digital services and commercial relationships that we have with companies every day. Second, control is an illusion. If you get an internet served ad and you see these little blue triangle icons that they have that is up there on the screen, you'll see that you can say, I want a different ad, but you never, even though the ad choices say you're in control, the choice of please stop tracking all of my behavior to serve me ads that you think are more likely to sucker me, that choice is never given to us. Similarly, control completes the creepy trap. So we're concerned about creepiness, and being given control, in a sense, further disempowers us. I was trying to read an article a little while ago about a case that I was involved in Ireland, involving Facebook and a litigant called Max Schrems. And I wanted to read the article on the Irish Independent, which is a website that I go to 2 or 3 times a year. And then a cookie pop-up came up, and I thought, oh, here we go again. And so I went through, they care about my privacy, they give me choices. And so I had all these different choices of storing and accessing, advertising. I could agree to all, because if I didn't, I actually went through and there were about 47 different choices of different things that I could choose. And then I could have individual granular choices for about 300 different advertising technology partners. And in the end, I just agreed to all because it was just not worth the effort to do it. I felt resigned. I gave up. But notice that the illusion of control completed the creepy trap, right? They said, well, hey, Richards, we gave you a choice. And I feel I had a choice to protect my privacy. There was a privacy pop-up, and I chose the agree to all button because it was a loaded system against me, and there was no way that we could actually exercise that level of control. They know that we're going to give up, but they know that we're also going to feel guilty and say, well, it's creepy, but I guess I had a choice and I failed to protect my privacy, so it's my fault. And that's just unacceptable. That's dishonest and fundamentally incorrect. Finally, control is insufficient. Other people's choices can affect your privacy. Your siblings can disclose, or your parents or children can disclose good chunks of your genetic history. That can be used to solve cases even without you doing anything. So control, even if it did all of the things that companies say it does, which it doesn't, it's an illusion and it's overwhelming and it completes the creepy trap. Even so, even if we solved all those problems, it would still be insufficient. Finally, there's the idea that privacy is dying, that if it's not dead, it's going away. This, incidentally, is George Orwell's gravestone. There are 3 claims here. First, tons of human information is being collected. This claim is undeniably true. Second, there's the claim that people don't care about privacy, and I think attendance on this call and public attention to privacy, and even the fact that the New York Times chose to write that editorial in that way about the end of privacy. They knew people were going to read because they do care about privacy. So that's undeniably false. But then companies say, well, it's okay not to share about privacy because sharing is awesome and drives innovation. And this is just an irrelevant question. Privacy is not dying. Companies and government security services would want us to believe that privacy is dying, but privacy is up for grabs because, recall, privacy is fundamentally about power. Finally, in maybe the next 5 minutes, I want to talk about the privacy values that I think that good privacy rules should serve. Privacy shouldn't be seen as an end in itself, but rather it should be seen as a means to other values. And those values are developing our identities, securing our political freedom, and developing consumer protection. First of all, on identity, 7 years ago, I wrote a book called Intellectual Privacy, which makes the argument that we need protection from surveillance or interference when we're making up our minds about generating ideas. Who are we? What do we believe in the world? When we're thinking, when we're reading, and when we're speaking with confidence. Our identities involve our intellectual freedom, our views on politics, but they also involve our personal freedom, our views on religion or sexuality or beauty. Necessarily, as human beings, we engage in play in developing our identities. Teenagers do this really well. They try on new identities. I was talking to my law students today, and they're saying, I've noticed that people are using big lawyer words in the first year of law school, right? We engage in these practices of play and identity navigation throughout our lives, throughout our days, as we figure out who we are. Now, when Mark Zuckerberg testified before Congress, first of all, he had to wear a suit, so this must have made him very grumpy. He said, you have one identity. The days of you having a different image for your work friends or co-workers or for the other people you know are probably coming to an end pretty quickly. Having two identities for yourself is an example of a lack of integrity. And this is just nonsense. All of us play, like this woman here, play different roles at different times in the day. We have professional roles, we have personal roles, we have anonymous roles, we are parents, children's, friends, lovers, students, consumers, doctors, whatever we play. And these roles require different actions from us. And to deny us the ability to maintain multiple identities is denying us the ability to be fully human. And good privacy rules enable us to maintain these different identities at different times, not in a way that is inauthentic, but in a way that is fully human and allows us to actually have real, meaningful, three-dimensional identities. Second, privacy is important to political freedom. The understanding of Big Brother is one that is highly visceral. There's also significant empirical evidence that when we are watched, whether we're employees in a restaurant or users of Wikipedia, when we know we're being watched, this inclines our behavior, our reading, our actions, and sometimes our beliefs to the boring, the bland, and the mainstream. Intellectual privacy, political privacy is essential if we are to develop authentic, individual, eccentric, uniquely autonomous political identities. Otherwise, we are being chilled, which is precisely why the NSA sought to find out the pornography habits of jihadi sympathizers. They found that sympathizers with Al-Qaeda watched a lot of pornography, and they found that clerics or media figures, these are not terrorists, these are people who had public personas, who were critics of US foreign policy, particularly during the Bush administration. And they found people who were clerics or preachers who were critical of US policies, many of whom were US persons and who were radicalized. I don't know who you think of when you hear that, but I think of this guy, Martin Luther King, who was all of those things, who was also surveilled by the US government, and the US government sent him a suicide note, basically saying, we know that you are having an affair on your wife, and if you don't stop your activities, essentially, or if you kill yourself, this is actually sent by the FBI, we're going to expose you as a fraud and destroy your reputation and degrade your movement. Now, King was assassinated before he could make that choice, but it shows the importance of privacy to political freedom, to the generation of new ideas, the importance of privacy to political dissenters. That's why the revelations of people like Edward Snowden and the Cambridge Analytica whistleblower are so important. Similarly, this is not just science fiction, right? The people of South Korea found a few years ago that their intelligence services had actually interfered in their elections in a sort of Cambridge Analytica way, because their spy services wanted candidate A to win because they thought he would be better for South Korea's national security than candidate B. And an information economy where the tools of political propaganda and psychological warfare can be deployed, knowing human information that allows the targeting of that payload, whether it's the South Korean scandal or Cambridge Analytica, or perhaps the next Australian election. It shows the practical importance of privacy to political freedom, as well as the theoretical importance. Finally, privacy is important for consumer protection. We think about consumer protection in terms of 19th century rules against factories and smokestacks, and we think about all the rules that were necessary to bring some of these technologies like the car under control. In most countries today, we deal with privacy under a notice and choice regime, where the notice is whatever you can hide at least in the United States in particular, the notice is whatever you can hide in a privacy policy, and the choice is whatever you can get away with. They don't have to use your service. I think it's important, as I argue in the book, to move towards a situated consumer, protecting consumers in an information economy where they actually are, rather than where neoliberal, sort of classical economic theory would have them assumed to be. It means building trust in digital platforms, and privacy rules are essential to build trust, which is the willingness of us to accept vulnerability to the access of others, to use these digital services. Trust, I think, is the missing ingredient in consumer protection rules and data security rules, and they're needed to build the trust that our society needs to survive and flourish. If there are good privacy rules, good security rules, we're better able to trust these companies when they say things like, "I've got your back," and we can avoid the fear that we are merely informational puppets dancing on the strings of the titans of digital industry, like the Mark Zuckerbergs and the aspiring Elon Musks of the world. So that's protection. So let me sum up and let Chris jump in with his remarks. I've talked about what privacy is. I've talked about what privacy isn't, and I've offered 3 privacy values. I think that as we build a digital society, we need to recognize privacy for what it is: a fundamental right that is essential, that is necessary for human flourishing in a digital world. In an information society that we live in, good rules around human information are essential if human beings are going to be able to flourish, to remain free, to be able to act as autonomous economic actors in a digital economy, and to effectively govern themselves and figure out who they are as human beings. And that ultimately is why privacy matters.
Neil, thanks so much. That was fascinating. And now I'm going to pass over to our commentator, Chris. You're wearing a tie, Chris. Very good.
I am. I suddenly realized we have 150 people still on board, so I thought I'd give them the benefit. So thank you, Jan, and thank you very much, Neil, as well. I've got a few notes that I've made. I want to first of all start by thanking Jennifer for the invitation to speak here, and Neil for that fantastic presentation. Intellectual privacy was absolutely required reading for those of us concerned about the intersection of privacy, not just with data protection law, but with the development of ideas, but particularly ideas in the digital environment. And it sounds very much as if this will be the same. So this is one to put on the list, the Christmas present list for everybody. I should say that reading intellectual privacy gave me a lot of thoughts. And I should say, of course, Neil and I bridge privacy and privacy. But we do say privacy in Australia. People will be able to tell by my accent that I am even more recently left England than Neil is.
Actually, Chris, I really enjoy the fact that normally Australians have this reputation for being itinerant expatriates, and today we have two English expatriates from different continents coming together in Australia.
And I was going to say we're homogenous because we're both Liverpool fans, so we're in a particularly perky mood this afternoon. It's a shame actually to be giving this response not in person, but I'm sure we all feel and hope that we're at the end of the pandemic entirely stopping our travel plans. So here's to meeting in person next time. So I just want to make 5 points. First of all, we have a very diverse audience, from regulators to law firms to academics to students. And in fact, my own students from Monash who've been studying with me artificial intelligence and the law, in the last week actually watched Neil explaining in conversation with Danielle Citron how the claim that people have nothing to hide is of course nonsense. And Neil and Danielle had this absolutely extraordinary exchange, making it very, very clear to people very, very fast that we all definitely have various things to hide. I will add, I also showed my students a classic 10-year-old video that you can see on your favorite video platform about Dave, the Belgian psychic, which if you haven't seen Dave explaining how he can read people's minds and then revealing that he's been hacked or he's been hacking people's bank accounts, then it's really worth having a look at. And one of the other things I think that my students really took from thinking about the intersection between looking at algorithmic regulation, looking at privacy and at data protection, is those thoughts about the need in a democracy to protect as much of our privacy about our opinion forming as possible. And Neil mentioned Cambridge Analytica, which of course is the case involving the manipulation of the election of President Trump and also the Brexit referendum in the United Kingdom. And in fact, that inspired a lot of work that I did on looking at the regulation of artificial intelligence, which is used to regulate us online. So Facebook and Twitter and other companies who have been using that to regulate us, of course, in the interest of having free and fair elections. And I did some work recently for the European Parliament and also for the Commonwealth on those things. I want to express my thanks to the Australian Electoral Commission, who sat on the steering committee for that Commonwealth effort. And hopefully it meant that we had a fairly clean election this year in Australia, although of course academic analysis needs to be ongoing. So apart from thinking about the primacy of privacy and people's opinion forming, I also want to note that it's really important to think about the fact that this is a multidisciplinary and multi-location challenge for us. So CLARS, of course, we look at commercial and regulatory law, but also, of course, we have to look at human rights. I'm also a member of the Castan Centre here at Monash. And we, of course, have to think about the intersection between these gigantic commercial interests, who are not just, of course, engaged in surveilling us commercially, but also engaged in surveilling us on behalf of government. The technologies that government uses are commercially supplied for the most part. I'll remind everyone, Edward Snowden was, of course, a Booz Allen Hamilton consultant working as a subcontractor for the National Security Agency. And so we have the importance of it, as Neil said, thinking about what's been going on in Silicon Valley and also in Seattle, in the companies that we call the GAFAM companies, Google, Apple, Facebook, Amazon, and Microsoft. Also what's been going on in Europe, and in particular that you have this importance of European law regulating United States companies, which creates an unusual dynamic. And so I'll ask Neil a couple of substantive thoughts about that, because I think he's demonstrated that individual resistance is hopeless, that we tend to agree to all kinds of invasive anti-privacy terms that we would otherwise, given a choice, choose not to adopt. My students were a little bit shocked when I told them that the cookie banner is actually an invention of the Interactive Advertising Bureau in order to frustrate the purposes of the Electronic Privacy Directive in Europe. It's designed to annoy us and make us feel futile. And I think it's achieved that almost beyond the dreams of those who designed this particularly privacy disabling technology. I'm not sure if there is an acronym for something which is not enabling, but it's actually disabling in terms of our privacy protections. And so the third point I want to make is about something which is known in the United States very often as the Brussels effect, the effect of European law on United States companies, particularly, of course, the GDPR. But in actual fact, there were a couple of thoughts about that which are important. The second is that around the world, and there's pressure in Australia to adopt some aspects of this, which we'll hopefully talk about in Q&A. People talk about the Brussels effect, people adopting GDPR. In most of the world, and I'll ask Neil a question about California later, it's actually more the Strasbourg effect, that actually people are adopting something which is not a direct copy of the European Union law, but which is actually a copy of the convention passed by the Council of Europe. So we have something like, I believe it's now 150 countries. The great Professor Graham Greenleaf keeps a count of the number of countries that have passed laws that approximate to Convention 108, to this Strasbourg effect, and it's over 150 countries now that have done so. But there is a problem, and I think all of us, particularly working lawyers, will be very, very aware of this. The problem is about enforcement. And there isn't necessarily very strong enforcement in many places, although we have had enforcement happening in slightly non-traditional places. And I want to note that China has some model data protection laws which it's put in place. And before people were prepared to hurl rocks and say, well, of course, that won't involve enforcement, there has been a fine handed out to Didi, to the ride-sharing app in China, which is over $1 billion US, 1.7 billion Australian dollars. Extraordinary enforcement taking place beyond the wildest dreams, I should say, of where we sit currently in Australia, also beyond the wildest dreams of any regulator in Europe, but of course much smaller than the record fine that was actually given out in the United States, which was for Facebook's breach of its earlier enforcement agreement over the Cambridge Analytica scandal. So the fourth thing I want to say is that in a way, what we've done around the world with copying to some extent European laws on this is a tribute to what I call the Port Arlington effect. And for those who don't know, Port Arlington was the seat of the Irish Data Protection Commissioner from 2006 until at least 2013. It's gradually been moving back to Dublin since then. It's a small railway junction in Ireland, and it's where the regulator went not to die, but to reform itself as it moved out of Dublin in a time when it was accused of not enforcing European law very, very much. The reason I call it the Port Arlington effect is because the regulator in Ireland regulates most of the large American companies. It doesn't regulate Amazon or eBay. Those are both regulated in the regulatory powerhouse, which is Luxembourg. But Ireland regulates almost all of the other major US companies that you care to think of. And it tends to not issue, to put it mildly, very large fines by comparison. So that enforcement effect, I think, is really important. So let me get on to a couple of questions for Neil about the Australian experience. We are currently in a position where there's been a review of the Privacy Act of 1988, which has, of course, been amended several times. And we're thinking about where we move towards next, particularly, of course, with the new government in place in the last couple of months. So are we moving towards California law? And if we do, is that a good thing? And I'm sure that Neil has some thoughts about California has passed a state privacy law, which of course affects some of the very largest internet companies and other companies like 23andMe, in as much as it exists. Is it a good thing to do so? And another thought, this may be a bit more technical, so feel free to ignore it. In Australia's actually been one of the pioneers of co-regulation, the idea that you pass a law and then you encourage industry to institute its own more or less binding codes of practice and other things underneath that law. And it's a very attractive model, which has been adopted in Europe a good deal, to some extent, aping what's happened in Australia. But is that kind of idea really a good way of dealing with the fundamental human rights that are concerned with privacy? And can you, for instance, co-regulate TikTok? There's obviously been this very recent scandal about the extent to which TikTok is channeling user data back to China, which I know is a live issue in in the United States. It's a live issue in the Australian Senate as well. So can you really adopt these kind of self or co-regulatory schemes when you're dealing with something as fundamental as this kind of flow of data? I've asked you several questions. You are not obliged to answer any of them, and I know we have some audience questions as well. But I just want to thank you again for a wonderful talk and what will be a fascinating read for us all.
Thank you, Chris. I'd love to spend an hour on each of those, but I know we have some excellent questions in the chat. Let me say briefly on a little bit on California and a little bit on co-regulation. I think on California, whether the United States is going to be regulated by the California effect, I think is very much up for grabs, because for the first time in half a century, it's actually looking like Congress might pass a comprehensive privacy law. The ADPPA is before Congress is very close to a legislative majority. It's sort of in a race of time, but before the election. And one of the things at issue there is preemption, maybe not preemption of California's law. And California's law is sort of a choice-based take on the GDPR, but preemption of other state laws. I think the solution, and this goes to the co-regulation point as well, is that we need to have the right balance between top-down do not regulate rules and cooperative rules. And I think I believe Australia, like Britain, like the United States, has had sort of the rise of neoliberal thinking since the 1970s. Personally, I think we've gone too far in the direction of letting business write rules for us. I think the example you gave about the cookie banner, or that I gave about the ad choices banner, shows some of the real perils of co-regulation, where the incentives between the consumers or citizens, which we also are, and businesses are divergent. I think we can probably trust companies to co-regulate in data security contexts when the customers and the businesses both share the common threat of the external hacker. But in privacy issues where there's the moral hazard of using information to monetizing information to manipulate consumers, I think it's very, very dangerous to give companies that meaningful ability to write their own rules, because they'll write the sorts of rules that we've seen, which are ones that are to their own benefit and possibly even undermining the overall regulatory scheme. The final thing that I'll say is, I think as we look to next generation rules in the United States, in Europe, and in Australia, and elsewhere around the world, it's important that we don't just parrot back the fair information practice tools of the 1970s, which are embodied in things like the GDPR and Convention 108 and even the ADPPA. I think privacy law should be more than a means of a series of steps that companies can get to have choice or control, or some fiction of choice or control. I think it's important to take some of those options off the table, to have, as FTC Commissioner Lina Khan recently called for, substantive restrictions rather than merely procedural mechanisms. And I think in my own work that I've done with my dear friend and colleague at Boston University, Woody Hartzog, we think that experiments with a duty of loyalty, requiring companies to act in consumers' best interests with respect to their data, represent a promising way forward that promotes both flexibility, scalability, and a reorientation of corporate incentives towards substantive goods of the sort that protect these human rights that we're so fond of saying that we're so fond of.
Thanks, Neil. Those comments just reminded me of, the great corporate investor, Charlie Munger, who said, "Show me the incentive and I will show you the outcome." So we have to keep that in mind. Now, we've got lots of questions here. I'm going to try to abridge some of them because some are quite long. Before we get on to them, I'd like to thank Lisa Derrimond, who sent through a comment saying, "Great talk." Thank you, Lisa. We've got a comment or question here from Daniel Levy from Greenfields Lawyers, which I think is quite interesting, where he says, "Isn't privacy doomed simply because the younger generations, our future leaders, don't appear to value privacy based on my limited experience with my kids and their friends?" And I think that's a really interesting question about whether the values of privacy are the same for different generations and across different jurisdictions. So do either of you have comments on that?
I have so much to say about that. What a great question. Thank you, Daniel, for asking it. This is something that I talk about actually in the book. When I talk about, I didn't have time to summarize everything in the book in the sort of 30-35 minutes that I had to talk today. But in the chapter where I talk about privacy being dying, I talk about a variation of this argument, which is that, well, privacy is dying because young people don't care about privacy. And again, this is an argument that has a lot of facial appeal, right? Young people tend to do things that scandalize us, older people, with their information, until we realize these are young people. Young people always do things that scandalize older people with respect to their information, but then young people turn into middle-aged people. And the things they do, the drug taking, maybe little young people, the risky behavior, surfing on the tops of cars that young people used to do when I was younger, being bad drivers, a lot of these behaviors change with age. So I think absolutely young people are going to have a different set of social norms with respect to what is appropriate to share and what is not appropriate to share and how to behave. But if we think about privacy not as speaking as myself here, sort of a crusty middle-aged person looking with dismay at the younger generation, and really as people who recognize that privacy is about power, we see that young people recognize that privacy is about power. Young people are much more likely to use VPNs and encrypted messages than older people. They're much more likely to use privacy settings. They're much more likely to orient their behavior, but in terms of privacy, but in terms of the power threats they see in their lives. And 17-year-olds, except the one that lives in my house because parenting, weird professor parenting, 17-year-olds aren't concerned about the Five Eyes network or the NSA or ad tech manipulation. They're concerned about their parents and their teachers and their football coaches and the other people they spend time with, and they orient their privacy behavior towards them because they know that gossip and innuendo and rumor and secrets and exposure can really affect them situated where they are as 17-year-olds. And I have no doubt that as 17, this is why teenagers, even though they might go on social media, they still close their bedroom doors and they still don't want their parents reading their diaries, because privacy is about power and it's about behaviors with relationship to the perceived threats that we have. And teenagers perceive different threats than adults, but teenagers invariably turn into adults with adult concerns. So I think the privacy norms of the future will be different, just like the privacy norms of the present are different from the privacy norms of the past. And they will vary across cultures and subcultures. But privacy is never going to stop mattering because information is never going to stop conferring social power over human beings. And that's why privacy matters.
Chris, any comments from you on that one?
Maybe just very quickly to say that teenagers turn into students, turn into law clerks, turn into law firm workers and partners, and they really do need protecting from the attempts to exploit their lesser interest perhaps in privacy as teenagers when you have less social capital. And companies like TikTok, to just choose one, are engaged in what I would call predatory privacy practices. They are getting people to share information, which is then being monetized for advertising and other purposes, in a way that people would probably not feel comfortable with later. And that's why this right to be obscure or right to be forgotten, which was introduced by the European Court of Justice, it is such an important general principle, not just something which should be applied for by individuals, but the need for people to erase those digital breadcrumbs which are no longer relevant is going to be extremely important going forward.
Let me have one more one-sentence thought to that, because I want to leave room for other questions. And it's that this generation of young people who spent 3 years locked in their rooms learning through computers, I think will be particularly sensitive to the effects of surveillance from centers of power, right? Education, technology, monitoring, learning management systems, algorithms that predict A-level results, and invasive test proctoring, academic dishonesty surveillance tools. I think this has been a very visceral, unfortunately, a very visceral object lesson to a whole generation of young people in the importance of privacy. Though on the plus side, it's also shown that the importance of in-person learning, which as a classroom teacher fills me with great joy.
We have a question from Margarita Vladimirova from Deakin University, which I think fits in with what you were just saying, Chris. She says she's a big fan of your work, Neil, and she's read all your articles and books, maybe more than you've read. She says privacy in the 19th century was called the right to be let alone. Again, that sort of right not to be part of all this mix. And Weston classified 4 types of privacy: intimacy, anonymity, reserve, and solitude. Do you think these definitions and classifications can still be applied in the modern world? And do you think that governments will choose to protect consumers over tech giants? Well, why don't you just talk about the 19th century versus now?
Yeah, it's interesting. I taught the Warren and Brandeis article in which the famous right to be let alone phrasing was popularized just on Monday. Yesterday, which was Tuesday here, in my second information privacy class of the semester to a new crop of students. And I think what's great about the Warren and Brandeis article and their approach to privacy is they gave us a word and they gave us a concept. What's problematic about it is that they didn't really define it very well. And I think their difficulty in defining privacy is one that has plagued us to the present day, other than its fixation on harm, which particularly in the United States system has continued to be a problem, one that has stood in the way of a lot of plaintiffs who have sought reasonable relief for, to my mind at least, clearly visceral and concrete privacy injuries. So I think what's interesting in looking backwards in time is that the past may be a foreign country, but it's still a country we recognize. And I think what's interesting is it's very easy for us as 21st century consumers to buy into this end of history narrative now that we all have personalized computers, and I mean we're literally talking on the video phone, right? That we were told in the 1980s was coming, and it's here. But I think history also points out to us that these things too shall pass, and there are timeless human needs and interests. We tend to call them fundamental rights, and privacy is one of them. And privacy, our ability to live authentic lives, to be let alone, to figure out for ourselves what is good or true or fun or real. Privacy is essential to maintaining that kind of vision of political and individual freedom that so many of our democracies, Australia, the United States, Britain, Europe, others are built on. The problem is we often didn't write privacy down until recently, because we took it for granted. And I think what we're seeing is the resurgence of an effort to articulate, what it is and why it matters, as we do with so many of our other fundamental rights necessarily over time.
So we have 2 interesting questions on the effect of COVID on privacy. So we've got David Patience, who asks, has COVID accelerated the attack on privacy? And Sean Mulcahy, who asks whether the increased attention to mandatory notification of infectious diseases and the collection and retention of health information, the pandemic has increased that, and whether you have any reflections on the privacy implications of this phenomenon. And Sean is from the Australian Research Centre in Sex, Health and Society.
What great questions. Do you want to take any of these, Chris? Do you have thought? I don't want to monopolize the conversation.
I just want to say that there's a couple of things that you said which I think it's worth pressing home. First is that, of course, privacy is something which has been recognized in the law for over 250 years. And whether you were teaching a class in the States, Australia, or the UK, you could teach NTIC in Carrington, which is a case just before the American Revolution and just before the settlement, the British invasion, as it were, of Australia. Which said that papers are often the dearest objects that any man may possess. Of course, the assumption was it was only the landed gentleman who was entitled to vote in those days, and its privacy was only extended to those who could defend it in that way. And so I think the idea of privacy is something in law which we've recognized for well over 250 years. And there is this tendency, which I know that you push back against, Neil, in your writing, to the assumption that somehow this is novel in the 21st century, or that it was a Brandeis idea which is only just now coming to fulfillment, is something to push back on a little bit. And on the COVID element, I think that there's a couple of things which I think are particularly fascinating. The first is the failure of the attempts by governments to introduce particularly privacy invasive apps for notification. And the interesting alliance between Google and Apple as effectively the governors of the smart app environment because of the app stores, and civil society activists trying to ensure a relatively privacy enabling use of that technology. So I don't know if that's a particularly a lesson of wider application, but we actually did see pushback against governments' attempts to really introduce quite extreme surveillance at the beginning of the pandemic. But Neil will have thoughts on that, I'm sure.
Yeah, I think that COVID is an interesting example, and public health and infectious disease is an interesting example, because it shows that information is power, right? That information about who is sick and where they are and what they're doing, and how infectious their strains are is tremendously powerful information that can be used for a variety of ends, right? Now, we hope it would be used for public interested public health, that in order to maximize the health of the population for a discrete period during an emergency. But of course, public health, for all of its well-meaning interests, is sort of a privacy upside down, right? Surveillance is not a dirty word to public health figures. They use it entirely uncritically as just knowing what is going on. And public health has often been an exception to, at least public health emergencies have been an exception to privacy rules. I think what COVID points up is not just the power of human information, but the way that human information can be used for good or for not good in the case of spurious or pretextual public health intervention measures. And I think the solution is to ensure that the privacy protections surrounding public health information are used for human values, that public health surveillance should not be used to interfere with identity or political freedom or consumer protection. But on the other hand, the countervailing interest of public health is one where I think substantial inroads to what we would traditionally think of as things that are private would be appropriate. The key in a democratic society is to build guardrails around the exercise of these powers, particularly the extraordinary use of these powers, to ensure they're not used to undermine, that they're used well, they're used in the public interest, they're used to benefit society and the individuals who comprise it, and not as a pretext for other things the government may just want to do that it's more convenient to articulate in public health terms.
And I know that there are concerns, that sort of tension with the use of surveillance, et cetera, in digital technology in China at the moment. We've got a question from my colleague, Marilyn Pittard, who's a professor of labour law, and she asks a question that was really resonating with me as you were giving your talk, Neil. She says employers, probably through lack of trust of their employees and to monitor or improve employee performance, use all sorts of devices to monitor, collect data about their employees, video surveillance, recording data through IT, biometric systems for access to buildings, computers, etc. Employees usually have to consent to these if they want a job. So there's that kind of false feeling of, choice. can regulation really effectively control these employers' practices? I mean, I wonder whether it is to do with lack of trust by employers, or whether it's more of this kind of privatization of regulation that, you know, corporations are expected to, you know, hunt out flawed systems and hunt out impropriety within the organisation. So any views on that?
I do. What a great question. I think I have a dear friend and colleague at Washington University called Pauline Kim, who is also a labor and employment scholar who's interested in privacy. And she and I have had a lot of conversations over the last 20 years about these questions. I feel very sorry for labor and employment scholars who are interested in privacy, because in most Western societies, that's an interesting question. Does that make sense to Australia as a southern society, but sort of culturally Western societies, right, including Australia and New Zealand? Most employees do have this relatively little, very small amount of power, and the notion of consent, Jennifer, as you point out, is even thinner and more farcical than it is in the internet context. That really is sort of, you know, short of consent at the point of a gun. You know, consent at the point of a pink slip or unemployment slip. So I think that when it comes to worker surveillance, it's a particularly dangerous time, because there are relatively weak legal protections for workers and for employees. At the same time, there's a massive surveillance tech industry which is flogging these products to businesses, often under fairly spurious claims about their efficacy, and significantly undermining a lot of their costs, like worker burnout, the administrative costs that are necessary to run these things, the effects on morale and productivity, and on the mental health of a workforce, whether at a particular company or in society as a whole. Can regulation deal with this? Yes, 100% yes. Will it? Maybe not. But let me say why I think it can do it. One of the slides that I skipped past because I wanted to leave time for Chris to talk rather than taking the entire hour to myself was a painting that my dad hung in the living room of our house in England when I was a little boy, by L.S. Lowry, who was the iconic painter of the Industrial Revolution. And Lowry painted workers and factories and people going to football matches and smokestacks, and it reminded me that the Industrial Revolution, if you think back to the north of England around 1890 or 1910, was a really bleak, awful place, and the experience of an industrial worker at that time was awful. The life expectancy was short, the quality of life was terrible, the social safety net was almost non-existent. Over many years, through the work of many, many people, using a variety of political and legal tools, we managed to bring many, not all, but many of the excesses of first-generation industrial capitalism in check, to make the experience of being a worker a reasonably pleasant one, that allowed for the creation of a middle-class life for many people in our capitalist democracies. That got undermined starting in the 1970s. That has been undermined by neoliberalism in a variety of guises ever since. And digital platforms have created another industrial revolution or another end of history. And so law can do this, but it's going to take probably as long as it took us to bring most of the first industrial revolution under control. There's no app to fix it. There's no patch that can solve these problems. It's going to take the sustained work of many people in many countries over many years. But I am optimistic that we can do it, if only for the fact that we've done it before, and I think we can do it again.
Well, Neil, we may not be at the end of history, but we are at the end of today's seminar. It's been absolutely great to have you with us. It's been great to have you with us, Chris. For all the people that have attended, thank you so much for joining us. If I can just mention before we leave off, we have our next Law and Business seminar on the 21st of October. And those of you that asked the questions about COVID will be interested in this one. It's Professor Kristen Van Zwieten from Oxford University and Ruth Higgins from the New South Wales Bar. They'll be speaking on what's a director to do, director's duties in the time of COVID. And if you want to hear more about data barons, we've got a very special event on the 19th of October. It's the annual Bob Baxt AO address, and it's going to be given this year by Professor Victor Mayer-Schönberger from Oxford, and it's on the topic access rules, what to do about the data barons. You might want to join in on that one, Chris. Oh, Chris, you're hosting it, I think.
Absolutely, I'm very happy to join it.
So Neil might want to listen to that one as well. I'm sorry I couldn't get through all the questions. We've got 20 questions in the Q&A box. It's been a wonderful discussion, everyone. So thank you and have a great day or great night, wherever you are.